Hello.
Hi, I'm just returning your call.
Hi, I had a question.
Sure.
Okay, I forgot what the paperwork uh that you were saying was called yesterday that
I'm
LaShelton asked you for.
the Discovery.
Yeah. Was it like a discovery book or something?
It wouldn't be a book. Usually, just like it's whatever the district attorney has that's evidence in the case.
Okay. Oh, my main question was if they like if let's say the court does have it and they choose not to give it to you, like what does that mean?
The court would never have it. The prosecutor's office has it.
Oh,
The court doesn't get the Discovery. The prosecutor has an obligation to turn Discovery over to um, the defense. Anything that they plan to use at trial, anything that might be exculpatory, they have to turn over uh, 10 days before trial.
okay. So like does they because I remember you said that they don't legally have to give it to you.
Until 10 days before trial.
No, I'm saying oh, okay. So if they choose not to give it to you in general, is that bad?
They, they can't not give it to me. No.
Okay. Because I was
Yeah.
confused. I'm like, so what happens if they don't give it to you? Then what?
Well, I mean, that would be a reason. I mean, they wouldn't be able to introduce anything at a trial if they didn't give defense counsel notice of that beforehand.
Okay. Also, is it legal for somebody to keep changing like the date and it still be like valid?
Yes.
How?
It's going to go based off what's in the indictment. So the fact that the warrant may have said 2017 and then they indicted it as 2014. I mean, dates get mixed up all the time. There's no, it's going to be based on how they indicted the case will be how it was tried. So in between 2013 and 2014, the state will have to present evidence that what they're alleging happened during that time frame. But just because the warrant says something different doesn't mean that that the case would be dismissed or anything.
No, but like, wouldn't that be like kind of invalid though? Because like the times keep changing.
No, it wouldn't be invalid. No, they're saying, like, when they indict the case, what they're saying is we can prove that this happened at this time. So that's what they're going on. Just because they may have thought it was a different date earlier doesn't change how they indicted the case. They got a grand jury to sign an indictment. They found probable cause for those dates. So that's what they're proceeding on.
Oh, also, it's been like stuff going around. Like I'm not really sure much about law, but it's something going around saying if the word true bill isn't like stamped or signed on your paperwork, it's invalid.
Yeah, no, that's it's not a very good claim. The a true bill was returned. It was, I understand that it was typed on there, but that, I don't think we're going to get a lot of headway with the courts complaining that it was typed instead of written.
No, but I'm saying, but if it was typed, wouldn't that make it like invalid? Because isn't it supposed to be signed or stamped?
It's supposed to be written on the indictment as returned as a true bill. The other thing I think that needs to be, even if the indictment was found invalid, they could just, and they needed to stamp it. Let's say that that's even true. They would need to. They could easily just do that. There's no. You're still well within the statute of limitations for these cases.
Okay, because there's just like so many questions.
Yeah, and I know the Shelton has those questions. I think that's why, he wanted to make those representations to the court himself, which certainly we can do. I can get him a hearing date for that. And, you know, he can bring that up to the court if he wants to represent himself.
Okay.
All right.
But would that be like a regular hearing, or would there be like another bond hearing?
It would be a regular hearing. Yeah. With the judge.
Okay. Well, I will let him know. I guess we figure out what's from there.
All right.
Okay.
All right. Take care.
All right. Bye-bye.